This is the time where you put all your hard work, which has taken possibly a few days or a week or so. Now you're going to compile that and put it in action. Now you are entering the war zone with your notes, which is your armor. And I remember Dr. L.M. Singhvi, he was a very senior advocate, an eminent jurist. He was also a member of parliament, very prominent person. Now, he once told me, he said the factor on which you would win your case is 30% based on your pleadings and file. So that entire hard work you've done over a week will help you quite a lot, obviously, for that 5 minutes presentation you're going to give in the court. But what will make you win a case is actually 70% will be based on how you present your arguments. And he used to say, that time I remember I was visiting London, and he said, when you visit London, you must visit the courts there. And in the courts, you must observe how the lawyers argue. And even in our courts here, in wherever you are located, if you are across the country, anywhere, any court, when you're free from your work and you're free in the court, you must sit in the court. I used to sit in the Chief Justice's court because most of your important matters are taken up there, or any writ court. And you see the style with which various senior advocates and other advocates are arguing. And see what style do you relate to, and try to adopt the techniques from that lawyer by observing. Trust me, observing is the best form of learning. I may give you the tips and the tricks, but end of the day, unless you see a lawyer arguing in the court, you will not be able to adopt. Unless you see how many various forms and styles are there in the court. I've seen senior advocates, and these are all winning cases, good lawyers. But in some cases, I've seen, I was there in the court again, and there was this very senior advocate. Whenever a situation arose where the judge did not, would ask a question or whatever, his way of presentation was, he would literally bow down and say, yes, my lords, please, my lords. And he would, literally flatter him with all the praises and things and then argue the case. Of course, he also won the case. But that's his style of arguing. Of course, he had a very strong case on facts, but that was his style of arguments, was where he would bow down and please the court and keep them in good humor and win the case. Another lawyer I saw, he was arguing in a tribunal, a senior advocate, a very prominent senior advocate. And I remember the judge got angry for some reason. He must be in a bad mood. And he was not ready to listen to the arguments. And the senior advocate said, listen, at least hear me out. And the judge said, sorry, there's no case made out, dismissed. And he threw the file. The senior advocate, I remember, he got equally angry. And he also threw the file. And he said, if my lords feel that throwing the file will conclude the argument, then even I can throw the file. Then there is no point for any lawyer to appear here because my lords have already made up their mind. I know at a younger stage we can't do this. He was a very senior advocate who did this. But then the judge picked that file back again and he heard the arguments of the lawyer. So various lawyers have various styles. Some are aggressive, some are, very docile, very elegant. You need to choose what's your personality and how you want to argue in court. In both the situations, I remember, though there in the second instance which I told you, there was a slight aggression. But post that, the way he covered it up, he was never disrespectful to the court. He may have been slightly aggressive, but it may sound more aggressive when I spoke about it, but the way he did it, there was an elegance in his aggression also. So while arguing in the court, you need to keep some very basic points in mind. First and foremost, you must be respectful to the court. Bow down, nothing wrong. These people have earned that place. Make eye contact with the judge. I always say this, arguing in the court is as good as reading psychology of the person sitting on the bench. I've seen lawyers argue, and while arguing, you can, while you're observing sitting at the back, and you can see the judge is totally not interested. He's reading the file, he's not even listening to the arguments, and the lawyer continues to make the arguments. End of the day, I don't know if the judge may or may not have heard him. So unless you have that eye contact with the judge, unless you are not just reading your notes or file, you need to, moment to moment, you need to look up and see whether the judge is actually listening to you or he has already lost interest in whatever you're arguing. Because at that stage, if he has lost interest, you've lost your case. So you need to bring back the attention of the judge. You can always put in some small sentences like, now the most important part of the case is this. When you see a judge's mind is going haywire, you can say, but the relevant portion here, my lords, this very interesting aspect which I would like to bring to the notice of this court. So, these small sentences in between would again bring back the attention of the judge to whatever you're saying. And of course, if you continue with your whatever reading you were doing, the judge will again lose interest. So don't let that happen. Keep your eye contact with the judge and try to get his attention to your arguments. And when you're arguing, like I said, please avoid just reading your pleadings. It should be a conversational tone. Speak to them. See what they want to hear. Answer them. Don't try to avoid it. And when arguing, to keep it more interesting, I always say this, even in your pleadings, you should do this. And even while arguing, you should do this. Keep your sentences short. Keeping sentences short helps in two things. One, your arguments remain to the point. They remain specific. And two, you don't lose focus of what you're trying to achieve at. Normally, the tendency is that you're arguing on a certain point you're trying to achieve, and then you suddenly have this tendency to explain a certain thing that which you have said. So then you start getting diverted and start explaining a part of that sentences, and you lose focus as to what actually your arguments were. Keeping your sentences short will help you remain in focus. And then another very important part that you need to keep in mind is that you should always, when you're arguing in the court, please address the court, not the opposite counsel. A lot of people have this tendency because, there are lawyers, there are all kinds of lawyers. So when you are arguing in the court, the opposite counsel may pitch in and some kind of a sentence saying, no, my lord, these people are cheats, these people are wrong, they are making a false statement. The tendency is that you lose track of your arguments and get diverted into answering the opposite counsel. How dare you tell me I'm a cheat? This is not a sentence. The fact is there in the documents. Why are you getting into an argument with the opposite counsel? Remain focused in the court. Tell the judge that, my lords, if my learned friend will give me the opportunity, I will be able to explain it to my lord, whatever he has his doubts. Or in whatever manner, address the court at all times, not to the opposite counsel. And another thing which I feel is very, very important, keep your personality right, dress properly, act professionally. These small things matter. It gives a great impact and impression in the court when you're arguing. Don't be shabbily dressed up when you come just because you were in a hurry. Change your bands if they have become dirty. A lot of people, they don't just care. And these small things matter in the court. Now, always, another very important thing which I feel is that you should always practice your arguments before a mirror or someone close to you. And if a person, maybe your friend or your relative or your brothers, sisters, your parents, whoever, in your initial days of your careers, practice and tell them your arguments about the case. Now, for sure they don't know anything about the case, about the facts of the case. But if your arguments to them has been able to make them understand what the case is, then, my friend, you have a good argument. Never go to the court thinking the judge must have read the file, so I just need to just focus on my points. No, you have to explain the entire background of the case. Of course, if the judge himself tells you, skip the facts, come to the point, then you can skip it. But always explain the entire facts. So if you see in most of the cases when in the court you go and hear a senior advocate arguing a case, now you don't know anything about that case, but if you sit down and listen to a good argument, while listening to the argument, you will actually be surprised that you will get to know entire thing about that case. So adopt these things in your own arguments. In fact, I've myself seen this, while some senior advocate, he was there in the courtroom and he was waiting for his turn to come for arguments. Maybe the next case was his case. And I could see him literally lip movements, practicing his arguments in that mute mode. The opening lines, when he will stand up, what is he going to say? That is the level. And that was a very senior advocate, a very gray-haired lawyer who was many years into practice. But still, he was doing this. Practicing even at that last moment, how you will begin your arguments. And that has a great impact. Your first opening line, giving the brief of the case, may actually tilt the mind of the judge into listening to your side of the story. So practice, always practice. Don't forget, you've become, all of us, no matter what the age, are called practicing lawyers.